this video, I'm going to be philosophizing on intellectual property, most concerned with the clearest violations of individual autonomy and or privacy, as the violations within intellectual property always pertain to distinctions within an individual's subjectivity, originating certain original instantiations within the meaningful utterances of thought. One draws from existing priors the original instantiations priori to the incipient productions of certain intellectual and or creative works from intellectual meaningful utterances of thought, well defined to communicate clearly what intellectual property is within one's creation in relation to the intellectual property violation and or the byproducts and or residuals and or derivatives one is responsible for bringing into existence. Meaning that the intellectual property may truly, uniquely, existingly hold the intrinsic processes and or intrinsic properties conducted within the existenza proof within the existence of certain internal and or external characteristics that constitute the existentia of the intellectual property in question and or within one's mind-body connections and or self, whom holds the existing prior self-knowledge and or self-awareness into the as a must be good enough and necessarily necessary conditions, constituting the existence of the self in relation to the existentia of the intrinsic processes and or intrinsic properties constitutional of the intellectual property, meaning that one whom is the individual whom is the originator and or creator intrinsically holds the unique self-knowledge and or self-awareness into the causations resulting in the creation of the intellectual property, compared to the violator, whom is always superficially related to the origination of the creation within the intellectual property, to lack the same original instantiations and or transformations within the self, resulting in distinct memories and or perspectives in terms of what is intrinsic to the intellectual property, not the individual whom is in possession and or whom has destroyed the intellectual property and or whom claims to be the originator and or creator. Meaning that had you looked at the, be it a book and or a painting and or lyrics within a song per se, each of those are intellectual property originating within a creator whom is the originator of the original work. Had another individual replicated and or imitated the work, would lack the causations to explain certain intrinsic processes and or intrinsic properties to be the distinct constitution constituted within the intellectual property to hold certain excuses and or justifications to communicate as to excuse one's subjective perception for judging the existing priors to allowance for one to conduct certain step-by-step creations of the original work that allowance for its shape and form unique to the individual whom is the instantiator and or original. So had you asked the individual whom is the imitator and or violator would more likely respond with more vagueness and or spurious relationships attempting to connect gaps in meaningful information compared to the individual whom has the clear history of the development within one's self that has transformed distinct, meaningful pathways within mind-body connections to engage distinct processes of the incipient original instantiations, and the processes opting for distinct options to hold special knowledge into how the original work could have been constituted otherwise, that the individual whom is the imitator may truly only imagine and or most likely does not even consider the distinct areas an individual had deliberated to question whether or not a certain phraseology was appropriate and or combination of the intellectual processes and or intellectual properties that one had thought another more appropriate process may be equally valid, yet judged it to be less meaningful for X rationale. One may elaborate and provide meaningful information. And it is often the intellectual property that is associated with the most serious criminal penalties and or criminal violations resultant from certain imminent risks and or threats that have more harm and or damage and or threat inflicted upon society that you may possibly imagine. For example, in some cases you have individuals whom, say, are working in a laboratory to create the formula for medicine and for a new medicine to treat diseases. And this could result in individuals whom, one, prevent the further production of the medicine, and or 1A, preventing the further production of the medicine results in individuals whom are expecting to receive treatment by X date to experience worsening health conditions and or die, and or B, may result in certain further misconducts to not uniquely prevent the production of medicine, yet in some cases result in retaliations and or further crimes in result from the individual whom is the violator, whom is masking the seriousness of the offense, perhaps certain tools and or technologies to perhaps break into the technology or the laboratory, and or fraud to have impersonated an individual, perhaps to get access to distinct passcodes to, in some cases, enter different secure locations, and or perhaps may have breached an individual's privacy to steal information on an individual's personal computer and or laptop with spy or surveillance software, violating not just an individual's individual autonomy, more so the privacy of that individual in order to commit the intellectual property theft and or violation, and or may further impersonate that individual and or engage in further crimes related to the potential benefits that the incipient of the byproducts and or residuals and or derivatives directly and or indirectly associated with the production of the intellectual property would have received had the individual been able to provide the services and or appropriate borrowing and or permissions to allowance others to appropriately benefit from one's intellectual work and or intellectual property, whom is uniquely, even in the borrowing and or permissions provided, the owner of the intellectual property and or the originator and or creator. That never is removed of the individual whom is the original instantiator. Within most, this is distinct than had I built a car from distinct parts and then sold that car. Now the make of the car and or the specific combinations would still be original, and or the existing rights and or freedoms to produce the certain make of the car is within an individual's human rights and or freedoms to always have ownership of the intellectual property. Yet one may sell the vehicle and or that vehicle may no longer be in one's rights or in freedoms to own per se under some certain conditions. One may in certain conditions also be able to retain the vehicle even upon selling it and deciding it was an inappropriate thing to do, and may still own the vehicle, be it that is original to the individual whom is the creator. So there are certain unique cases, yet the intellectual property is always within an individual's rights and or freedoms whom is strictly the originator and or creator. And that might be a little bit more complicated for individuals to wrap their head around in terms of cases of engineering original materials and then selling those materials and then being able to seize those materials after selling it without providing a refund. Yes, individuals whom are the originators of those goods and or byproducts and or residuals and or derivatives still own and or may seize lawfully those original works. It's distinct than had one been modifying, say, a computer per se, yet even in terms of a computer, there may be certain original work that one may be allowance to seize the intellectual property of. So, but that typically tends to also be more complicated, and there are more caveats in terms of the deliberations into what one is allowance to retrieve. Yet, be it that it's, say, within the software programming, it's more the concern is not so much the hardware of the computer per se, yet retrieving the stored information from the unique areas of the hardware. So it's not necessarily the entire computer that is of meaningful concern within the intellectual property case. Though the proportionality is always of meaningful concern when considering the risks and or harms and or injury, be it that there is sensitive information that could result in more serious injury to others, yes, the entire computer may be seized. In terms of the protection of the public as the most meaningful concern, in the case that you have, for example, passcodes in terms of, say, safeguards on nuclear weapons, the threat is extremely high, and seizing the computer would be most meaningful and or pressing to be able to retrieve what is most meaningful and prevent negligence resulting in